Welcome to Talk Trials.
It's great to be here.
We are diving back into the machinery of the federal courts today. And usually when we sit down for one of these deep dives, we're tackling these huge, really consequential opinions.
Right. Landmark cases, Supreme Court decisions that change everything, or a circuit court opinion that redefines, an entire industry.
Exactly. But today, we're doing something a little different. We're going to zoom in. Way in. We're looking at a single 3-page order that, honestly, if you were just scrolling through the docket, you might skip right past it.
You'd think it was just administrative housekeeping, a bit of procedural cleanup.
But it's not. As we always say, the devil is really in the details. Or in this case, I guess, the devil is in the docketing.
That's a perfect way to put it.
This is a professional Federal Circuit Court of Appeals opinion analysis deep dive. The case is Carley v. Saalwaechter Inc. That's Saalwaechter. The appeal number is 2026-1001.
And this isn't about, a multi-billion-dollar patent dispute between tech giants. It's not about a big pharmaceutical company.
No. This is about a home foreclosure, a simple mistake, and a very, very specific kind of legal traffic control.
And it really is a perfect case study for understanding the boundaries of the federal court system. I mean, we talk a lot about the power of courts, what they can do, but today is all about the limits of that power. It's about what happens when a court has to say, I can't help you.
And maybe more importantly, I am not allowed to help you.
Exactly.
So let's set the scene here. I really want you, our listener, to get into the shoes of the litigant. So imagine you're Nanette Carley.
Yeah.
You're a regular person. You don't have a whole army of lawyers on retainer.
No fancy downtown office.
Not at all. You're a homeowner in Texas.
Specifically, you're in the jurisdiction of the United States District Court for the Southern District of Texas.
Right. And you're in a dispute over a foreclosure. This is your home we're talking about. So the stakes couldn't be higher for you personally. It's emotional. It's everything.
It's the biggest asset most people will ever have.
Absolutely. And you've been fighting this battle in the district court. You're suing a company, Saalwaechter Inc., a few individuals, and you've even brought in the local school district and the county.
Which, as a side note, almost always suggests that there are property tax issues involved, tax liens on top of whatever mortgage dispute is happening.
So you're fighting on all fronts. And then the gavel comes down. On August 25, 2025, the district court judge dismisses your case entirely.
You lose.
You lose. And that is just a gut punch for any litigant. The entire system has just told you no.
It's a heavy moment, but you're not done fighting.
No, you're not. You feel the judge got it wrong. Maybe you think the whole process was unfair, that something wasn't right. You want to appeal. You want a higher court to take a second look.
The right to appeal is fundamental.
It is. So you sit down to file your notice of appeal. Now, normally, if you're in Texas and you want to appeal a federal court's decision, where does that appeal go?
Well, geographically, it goes to New Orleans. That's the home of the United States Court of Appeals for the Fifth Circuit. The Fifth Circuit covers Texas, Louisiana, and Mississippi. It's a geographic certainty. You file in a Texas federal court, your appeal goes to the Fifth, period.
But Ms. Carley, she doesn't do that. And we don't know why for sure. Maybe she sees the name Federal Circuit and thinks, well, this is a federal case, so it must go to the Federal Circuit.
That's an understandable mistake for a layperson. The names are confusing.
They really are. Or maybe she thought it sounded more important. Who knows? But whatever the reason, instead of sending her paperwork to New Orleans, she mails it to the United States Court of Appeals for the Federal Circuit.
In Washington, D.C.
She knocks on the completely wrong courthouse door.
And that single mistake, that wrong address, triggers this fascinating cascade of statutory dominoes. It's a classic wrong door problem.
And that really is the core question for us today. What happens when a litigant knocks on the wrong door? Does the Federal Circuit just slam it shut in their face, say, too bad, so sad?
Or do they do something else? Do they act like a helpful traffic cop and actually point you in the right direction?
It's a question about jurisdiction, sure, but it's also about fairness, about equity. So our mission for this deep dive is to analyze the Federal Circuit's order, which came down on December 15th, 2025.
We're going to break down those strict jurisdictional lanes that Congress created for this very specific court under the statute, 28 USC Section 1295.
And then we're going to unpack the incredible remedial power of transfer, which is found in another part of Title 28.
And through all of that, we're going to find out how this case is still alive today, despite being filed in, the completely wrong court.
It's a procedural survival story, is what it is.
Like that. A survival story.
Okay, let's start with the snapshot before we get lost in the statutory weeds. Give us the bottom line. What did the Federal Circuit actually do in this 3-page order?
The holding is very clear, very crisp. The Federal Circuit declared without any ambiguity whatsoever that it lacked jurisdiction over Mrs. Carley's appeal.
Okay, so no power.
No power.
Cool.
They looked at the case and said, we have absolutely no authority to hear this.
So if they have no authority, I have to assume they just dismissed it, right? Case dismissed for lack of jurisdiction. We see that all the time.
And that's the key. No, they did not dismiss it.
Really?
Instead of dismissing the case, which, by the way, would have almost certainly ended Miss Carley's legal battle for good because of missed deadlines, the court ordered a transfer.
A transfer.
They literally sent the entire case file over to the United States Court of Appeals for the Fifth Circuit.
So they essentially picked up the file, put it in a digital envelope, and mailed it to the correct address in New Orleans.
That's precisely what they did.
So who was on the panel? Who made this call?
We had a panel of 3 judges, Circuit Judge Reyna, Circuit Judge Bryson, and Circuit Judge Stark.
That's a serious panel. I mean, Judge Bryson has been on that court for decades.
Since 1994, I believe. These are judges who have seen everything. They know the Federal Circuit's jurisdiction inside and out. They are true experts on the limits of their own court's power.
So this wasn't a rookie mistake on their part. They knew exactly what they were doing.
Oh, absolutely. And it's important to note how they issued the decision. It's a per curiam order.
Okay, let's pause on that term for a second. Per curiam. We see it a lot, especially in these kinds of procedural orders. What does that phrase actually signal to us, the court watchers?
Well, literally, it's Latin for by the court. And in practice, what it means is that the opinion isn't signed by a specific individual author. You won't see Reyna J. writing for the court at the top.
It's anonymous in a way.
It's presented as the collective, unified voice of the entire panel. It usually signals a few things. First, that the decision was unanimous.
No dissent.
No dissent. Second, that the issue is relatively routine and is just an application of clearly settled law. There's no big new legal ground being broken here.
So it's the court speaking as an institution.
Exactly. As an institution, rather than as a collection of 3 individual judges with their own judicial philosophies. It's the court saying, this is just how it's done. This is black letter law.
It feels sufficient. Like they looked at the papers, all nodded, and just said, yep, transfer.
I suspect that's very close to what actually happened. And to add to that, the order is designated as non-precedential. Which means they are explicitly saying, we are not making new law here. Other courts and future panels aren't bound by this decision. It resolves this one case, and that's it. They're just trying to clear their docket of a case that simply doesn't belong there.
It really reinforces your traffic cop analogy from earlier.
Let's explore that. Think about what a traffic cop at a busy intersection does. They don't write the traffic laws. They didn't design the roads.
Right.
They just stand there and make sure cars go where they're supposed to go. They look at a car and say, you, in the truck, you can't make a U-turn here. Go straight.
And that's what the Federal Circuit is doing here.
It's exactly what they're doing. They're not looking at the merits of Mrs. Carley's foreclosure case. They're not examining the evidence or the district judge's reasoning.
They're not judging the quality of her driving, so to speak.
Perfect analogy. They're just looking at the license plate on her appeal and saying, ma'am, you are in the wrong jurisdictional lane. You need to be over there.
But unlike a normal road, you can't just merge over. The lanes in the federal judiciary are built with, like, solid concrete walls.
That's the whole issue. You can't just merge. You need a special statutory crane to lift you out of the wrong lane and place you in the right one. And that's what we're going to talk about.
Okay, let's get into the deep dives then. Let's unpack this case piece by piece, starting with the procedural facts. We've touched on the basics, but let's get granular.
Let's do it.
Segment 1, the procedural facts. So, we have Nanette Carley, the appellant, and on the other side, we have a whole list of appellees.
Yes, Saalwaechter Inc., an individual named David Saalwaechter, another individual, J. Randall Bays, and then 2 government entities, Tomball Independent School District and the County of Montgomery.
It really isn't everything but the kitchen sink kind of lawsuit. You've got the corporation, the individual who likely runs it, maybe a lawyer, a trustee, and J. Randall Bays, and then the local government.
Like we said, when you see a school district and a county named in a foreclosure suit, it almost always points to a battle over unpaid property taxes. In Texas, property taxes are a huge deal and a common cause for foreclosure, right alongside mortgage defaults.
So Miss Carly wasn't just fighting her bank, she was fighting the local government too.
It seems that way. A multi-front war over the debts on her property.
And all of this took place in the Southern District of Texas, presided over by Judge Alfred H. Bennett.
A standard federal district court handling all sorts of federal cases day in and day out.
Now, the timeline. I really want to stress this because when we get to the loose ends of this case later on, these dates are going to matter a lot.
Legal analysis at its core is often just a fancy way of looking at a calendar. So let's nail down the key dates.
Date number.
August 25, 2025. This is when the district court enters its final judgment. The case is dismissed. The gavel falls.
Okay, so in theory, the 30-day clock for an appeal starts ticking right then.
Usually, yes, but things get complicated fast. About 2 weeks later, on September 9, 2025, Mrs. Carly files a new motion in the district court.
Not the appeal yet. Another motion.
Another motion, and a very specific one. She files it citing the statute 28 USC Section 144.
We have to sidebar on Section 144. This is not your standard motion to reconsider. This is something much more serious.
Oh, it's a huge deal. Section 144 is the federal statute that allows a party to seek the disqualification of a judge based on bias or prejudice.
You're essentially accusing the judge of not being impartial.
You're saying, this judge has a personal bias against me or in favor of the other side, and therefore they cannot be fair. I want them off the case. It's a direct challenge to the integrity of the judge.
That feels like a legal nuclear option.
It's a very aggressive move. It has to be supported by a detailed affidavit from the party stating the specific facts and reasons for their belief that bias exists. You can't just say, I don't like the judge's rulings.
And here is the absolutely crucial procedural fact for our later discussion. When Mrs. Carly eventually filed her appeal, this bias motion was still pending.
The district court hadn't ruled on it yet. It was just sitting there on the docket.
So the case is in this bizarre procedural limbo. The final judgment has been entered, but now there's this unresolved, very serious motion accusing the judge of bias.
Exactly. And right in the middle of that limbo, on September 25, 2025, Mrs. Carly files her notice of appeal.
And she specifically directs it to the Federal Circuit.
Right. She jumps the gun on the appeal, perhaps, or maybe she thinks she has to file to preserve her rights against that August 25th judgment. But the key mistake is she sends it to D.C. instead of New Orleans.
So the file lands on a clerk's desk at the Federal Circuit. What happens then? Do they schedule oral arguments? Do they call in the lawyers?
No, nothing like that. They do what any good appellate court does when it smells a jurisdictional rat.
Which is?
They issue what's called a show cause order. This happened pretty quickly on October 16, 2025.
Show cause. It sounds so formal and ominous.
It is. It's the court basically sending a letter to all the parties that says, we've looked at your filing, and we cannot, for the life of us, see why we are allowed to hear this case. Please write back and explain to us, show us the cause, why we have jurisdiction. Otherwise, we're going to kick this out.
So it puts the burden of proof squarely on the parties to justify their presence in that court.
Completely. Tell us why you belong here.
And what did the parties say in response? Let's start with the appellees, Saalwaechter and the county and so on.
They filed a response, and they were very sensible. They basically said, we agree with you, Your Honors. You don't have jurisdiction. You should either dismiss this appeal or, in the alternative, transfer it to the proper court, which is the Fifth Circuit.
Okay, that makes sense. They just want the case to move forward in the right place. What about Mrs. Carly? What was her argument for why the Federal Circuit had jurisdiction?
Silence.
What do you mean silence?
She did not file a response to the show cause order.
She just ignored it. A direct order from a United States Court of Appeals.
It appears so. She never filed a brief or a letter explaining why she thought her case belonged there.
To me, that is just baffling. But it also seems to be the strongest evidence yet that she was proceeding pro se.
I think that's almost a certainty. Any lawyer, even a first-year associate, knows that when a circuit court issues a show cause order, you drop everything and you answer it. It's a 5-alarm fire. Ignoring it is usually fatal to your case.
So she either didn't understand what the order meant, or she was simply too overwhelmed by the process to respond.
Either way, her silence left the court with only one option: to analyze its own jurisdiction based on the filings it had.
Which brings us neatly to segment 2, the jurisdictional analysis. This is the why. Why, specifically, is the Federal Circuit the wrong place? Why can't they just say, well, it's a federal case, we're a federal court, let's just hear it and be done with it?
Because the entire federal court system is built on the principle of limited jurisdiction. A court doesn't have power just because it exists. Its power is granted and strictly limited by the Constitution and by statutes passed by Congress.
You can't just wander into any courtroom and demand a hearing.
No. And the U.S. Court of Appeals for the Federal Circuit is the most limited, most specialized of them all. Its jurisdiction is almost entirely laid out in one statute, 28 USC Section 1295.
I like to think of Section 1295 as the menu for the Federal Circuit. If your type of case isn't on that menu, they simply cannot serve you.
That's a perfect analogy, and it is a very, very short menu. Most of the other circuit courts, the 1st through the 11th plus the D.C. Circuit, are what we call courts of general appellate jurisdiction.
They're geographic.
They're geographic. They hear almost any kind of federal appeal that comes from the district courts within their specific region. The Federal Circuit is different. It's thematic. It has nationwide jurisdiction, but only for a handful of very specific subjects.
Okay, so let's run the diagnostic. Let's go down the menu and see if Mrs. Carley's case matches anything. Lane 1, the big one, patents. This is under Section 1295A1.
This is the court's bread and butter. It's the whole reason the court was created back in 1982 to take all patent appeals from every district court in the country and create a single, uniform, coherent body of patent law.
So instead of having the Second Circuit disagreeing with the Ninth Circuit on a patent issue, creating confusion, all roads lead to one place.
All roads lead to the Federal Circuit. If you have a patent infringement case in Texas or California or Florida, the appeal goes to them.
So is Carley v. Saalwaechter a patent case?
Not even close. Unless Mrs. Carley invented and patented a new method for foreclosing on a house, there's no patent issue here. It's a property dispute. So lane 1 is firmly closed.
Okay, what's next on the menu? Lane 2, the PTO, the United States Patent and Trademark Office. That's Section 1295A4.
Right. This covers appeals from administrative decisions. So if you apply for a trademark and the PTO's Trademark Trial and Appeal Board denies it, you can appeal that final decision to the Federal Circuit. Same with patent applications.
It's a review of an agency's action.
Exactly. But did this case originate at the PTO?
No, it came from the U.S. District Court for the Southern District of Texas.
Oh.
So lane 2 is also closed.
Slam shut.
All right, what else is there? Lane 3, the Little Tucker Act. This one, Section 1295A2, is a bit more obscure, but it comes up.
It does. The Tucker Act and the Little Tucker Act are all about sovereign immunity. The basic principle is you can't sue the government unless it gives you permission.
You can't sue the king.
Exactly. The Tucker Acts are the statutes where Congress gave that permission, waiving sovereign immunity for certain types of claims for money damages against the United States.
And if your claim is for less than $10,000, that's the Little Tucker Act part, and you lose in the district court, your appeal goes to the Federal Circuit.
Correct. But there is a huge glaring condition that has to be met. The defendant in the case must be the United States federal government.
And who are the defendants in Miss Carley's case?
A private company, private individuals, a school district, and a county.
A school district and a county are government, but they aren't the United States.
Not for the purposes of this statute. They are local government entities, arms of the state of Texas. They are not the federal government. So the Little Tucker Act is completely inapplicable. Lane 3 is closed.
It really seems like Miss Carley struck out. She missed on every single count.
Completely and utterly. There is no hook. There is no clever argument or loophole to be found. This is a standard civil appeal arising from a district court in Texas.
And we've already established where those are supposed to go.
If you go to the Fifth Circuit, it's automatic. It's not a choice.
So the jurisdictional defect is clear. It's not a close call. The Federal Circuit looks at the menu, sees that Mrs. Carley ordered something they don't even have in the kitchen, and now they have to clear the table.
A very apt way to put it.
This leads us directly to segment 3, the remedy, the what now. If they have no power, why didn't they just dismiss the case? Why transfer?
This is where we get into the real compassionate machinery of the federal system. We have to look at another statute, 28 USC Section 1631.
The title of that statute is literally Transfer to Cure Want of Jurisdiction.
It does exactly what it says on the tin. The statute says that whenever an action is filed in a court that finds it lacks jurisdiction, the court shall, if it is in the interest of justice, transfer that action to any other court where it could have been brought in the first place.
Two key phrases there, shall and in the interest of justice.
Yes. Shall is mandatory language. It's not may, it's shall. It creates a presumption in favor of transfer, and then you have that powerful, flexible standard in the interest of justice.
What does that actually mean in practice?
It's a system safety valve. It's a recognition by Congress that the law is complex, the court system is confusing, and litigants, especially pro se litigants, are going to make mistakes. Filing in the wrong court is a classic technical error. It's not a malicious act. It's not a substantive flaw in your argument. It's just a wrong address.
So let's play this out. What would have happened to Mrs. Carley's case if the court had just dismissed it on December 15th, 2025?
This is the absolutely critical part. If they had dismissed it, her only recourse would be to immediately try to file a new notice of appeal, this time in the correct court, the Fifth Circuit.
Okay.
But remember the calendar. The original judgment she was appealing was entered on August 25th. The deadline to file a notice of appeal in a civil case is typically 30 days.
So by December, she is months and months too late.
Exactly. If she tried to file a new appeal in December, the Fifth Circuit's clerk would look at the dates, see it was wildly out of time, and reject it on the spot. Her appeal would be dead before it even began.
Wow.
But Section 1631 performs a kind of legal magic trick.
It's a time machine.
It's a time machine. The statute says that when a case is transferred, the action shall proceed as if it had been filed in the court to which it is transferred on the date upon which it was actually filed in. The
Wow.
court from which it is transferred.
That is a mouthful of legalese, but let's translate that into plain English.
It means the court engages in a legal fiction. We all agree to pretend that on September 25, when Mrs. Carley filed her papers in Washington, D.C., she actually filed them in New Orleans. The Fifth Circuit has to treat her appeal as if it arrived on their doorstep on September 25.
It preserves her original filing date. It freezes time at the moment of the mistake and retroactively corrects it.
And by doing that, it saves her case from being dismissed as untimely. That is why transfer is almost always in the interest of justice. It allows the appeal to be decided on its merits rather than dying on a procedural technicality.
It's fundamentally about fairness. It's the court system saying, look, you messed up the address, but we're not going to let that one mistake cost you your constitutional right to an appeal.
Precisely. It's a moment of grace built into the system.
However, there's always a however, isn't there?
Always.
We have to talk about segment 4, the loose end, the timeliness problem, because there is a fascinating footnote in this order. Footnote 1.
Ah, yes. The footnote. This is the court's way of saying, we've solved one problem, but we're handing you another. I call it the we're not touching that with a 10-foot pole footnote.
So the footnote says, and I'm quoting, "We leave any issues as to the timeliness of Ms. Carley's notice of appeal for the Fifth Circuit to resolve." Now, wait a minute. We just spent all this time saying the transfer preserves the September 25th filing date?
Mm-hmm.
That date is 31 days after the August 25th judgment. 31 days. So that seems, on its face, like it might be one day late, right? Why is there even a question for the Fifth Circuit to resolve?
The question comes back to that other motion we talked about, the really aggressive one.
The judicial bias motion, the Section 144 motion that she filed on September 9th.
Exactly, the one that was still pending when she filed her appeal. Because under the federal rules of appellate procedure, specifically Rule 4, certain types of post-judgment motions have a special power. They toll the time to appeal.
Toll meaning they stop the clock.
They hit the pause button. If a party files, for example, a timely motion to alter or amend the judgment under Rule 59, the 30-day appeal clock doesn't even start running until the district judge rules on that motion.
And what happens if you file your notice of appeal before the judge rules on that clock-stopping motion?
Well, the rules say your notice of appeal is basically held in abeyance. It's treated as dormant. It only becomes effective on the day the judge finally decides that last pending motion.
So the big tricky legal question here is, does a motion for recusal of the judge under Section 144 count as one of those special clock-stopping motions under Rule 4?
And that is a very thorny legal question. The rule lists specific motions that have this tolling effect, motions under Rule 59, Rule 60, Rule 50. A motion for judicial recusal isn't explicitly on that list in the same clear way.
So you have these two competing scenarios. Scenario A, the motion does toll the time. If that's the case, her appeal filed on September 25th might actually be premature. It's filed too early because the district court hasn't finished its work yet.
Right, it's not ripe for appeal.
Okay, scenario B. The motion does not toll the time. In that case, the clock started on August 25th and it just kept ticking. She filed on September 25th, which is day 31.
And then the question becomes, was day 30 a Sunday or a federal holiday? If so, the deadline rolls over to the next business day, and she might be fine. If not, she's 1 day late, and being 1 day late is the same as being a year late. You miss the deadline, you're out.
So there is this huge cloud of uncertainty hanging over the timeliness of her appeal. Is it too early? Is it too late? Or is it, by some miracle, just right?
Exactly. And the Federal Circuit looked at this complicated, messy cloud.
And they said, not it.
They passed the buck. But, and this is a crucial point of legal doctrine, they had to pass the buck. It was the only correct move.
Explain that. Why couldn't they just look at the calendar, look up the rule, and give her an answer? It would seem more efficient.
It might seem that way, but it would be a profound legal error because of jurisdiction. Remember, the entire premise of the Federal Circuit's order is that they have no power over this case. If you have no power to decide the ultimate merits of the case, whether the foreclosure was lawful, then you also lack the power to decide these kinds of gateway procedural questions like timeliness.
If you're not the referee of the game, you don't get to decide if a player was offsides.
Perfect. That's exactly it. If the Federal Circuit had issued a ruling on timeliness, they would have been exercising judicial authority over a dispute they have already admitted on page 1 of their order that they cannot hear. It would be a complete contradiction.
So the only legally pure, doctrinally consistent move is to package the whole messy thing up, the appeal, the weird timing question, the pending bias motion, and ship it all over to the Fifth Circuit.
Dear Fifth Circuit, this is your problem now. You figure it out.
That's effectively the message. And it's the right message, because the Fifth Circuit is the proper body to interpret its own rules of procedure and to decide whether an appeal from one of its own district courts was timely filed. It belongs to them.
It's an act of profound judicial restraint. It's the court staying scrupulously within its own lane, even when it might be tempting to just clean up the mess themselves.
It's fascinating.
Yeah.
Okay, let's zoom out a bit to the broader legal context and significance. We've dissected the mechanics, but what does an order like this tell us about the people involved and the system itself? We keep coming back to the pro se aspect.
It's the unspoken subtext of the entire order. Look, lawyers make mistakes too, of course, but filing a Texas foreclosure appeal in the Federal Circuit is a classic hallmark of a self-represented litigant.
It suggests someone who is navigating the system using, I don't know, intuition or maybe just Google, rather than a deep knowledge of the federal rules of appellate procedure.
And the system, with all its deadlines and arcane rules, can be brutal for people in that position. It's almost designed to trip you up if you don't know the secret handshakes.
It really is. But that's precisely why a statute like Section 1631 is so beautiful and so important. It acts as a bucker. It's a recognition by Congress that the complexity of the federal system shouldn't be an inescapable trap for the unwary.
If this transfer statute didn't exist, the Federal Circuit would have been forced, by its own jurisdictional limits, to dismiss Mrs. Carley's appeal. She would have been time-barred. She would have lost her chance to appeal the loss of her home because she put the wrong address on an envelope.
And that just feels fundamentally unjust.
And Congress agreed. That's why they passed Section 1631. And what's really interesting is the timing. They enacted it in 1982.
Wait, 1982? That's the same year they created the Federal Circuit itself.
It is not a coincidence. Congress knew that by creating this new, highly specialized court with these confusing jurisdictional lanes, they were going to cause this exact problem. They knew people would get confused and file in the wrong place.
So the creation of the safety valve transfer statute was a direct and necessary companion to the creation of the confusing court structure in the first place.
Absolutely. You can't build a complicated maze without also building in a few emergency exits for people who get lost. Section 1631 is that emergency exit.
So what happens next for the Fifth Circuit? They get this digital packet of files from Washington. What's the first thing on their to-do list?
Well, first they have a headache on their hands. They have to open a new case file and docket everything. Then they have to confront that timeliness issue from footnote 1 head-on.
Right.
They'll have to look at the Section 144 bias motion. Is it still pending down in the district court? If it is, the Fifth Circuit might have to pause the appeal and remand it, send it back down, with instructions for the district judge to please rule on the motion accusing him of bias.
Because you can't really have a proper appeal going on while the trial court is still technically working on the case.
Generally, no. You need a truly final judgment. Or the Fifth Circuit might just look at the calendar and say, you know what, we don't think a Section 144 motion tolls the time. You filed on day 31, you're late, appeal dismiss.
So Ms. Carley is by no means out of the woods.
Not at all. She has just been transferred from one part of the forest to another.
But at least she's in the right forest now.
Yes. She has a fighting chance to be heard by the court that's actually supposed to hear her. And that's everything.
It's just so interesting. We often think of courts as these rigid, unyielding institutions, stone fortresses with inflexible rules. But here we see a mechanism that is designed to be flexible. It's designed to catch people when they fall through the cracks.
And it serves the principle of judicial economy, too. It's a massive waste of everyone's time and money to have a case dismissed on a technicality, only to have the litigant then file a new lawsuit about whether the first dismissal was proper. It's much cleaner, faster, and fairer to just move the file to the right place and get on with it.
All accomplished in 3 short pages.
3 pages, 3 judges, and a whole lot of complex machinery working quietly and correctly in the background.
That really is the federal court system in a nutshell.
When it works.
Well, speaking of the machinery, I think it's time for us to step into the machine ourselves.
I'm ready. Let's do it.
Now, we take our seat as the 10th chair.
The 10th chair.
For our listeners who may be new, the Federal Circuit typically hears cases in panels of 3 judges, but there are 12 active judges on the court in total. So in this segment, we like to imagine ourselves as that extra voice in the room. We've read the briefs, we've reviewed the statutes. If the Talk Trials hosts were on the panel for Carly v. Saalwaechter, how would we have ruled?
I'm picturing myself in that conference room, looking at the draft order on the table, and I am voting aye. A firm aye.
You're affirming the panel's decision to transfer the case.
100%. I concur entirely with Judges Reyna, Bryson, and Stark. This was the only correct outcome.
I am right there with you. It's a unanimous vote from the 10th chair. We affirm the transfer. But let's break down our reasoning. Let's not just say we agree. Let's explain why we are so certain.
Okay. Reason number 1 for me is jurisdictional clarity. The lack of jurisdiction here isn't a suggestion, it's an absolute. There is no gray area. There is no plausible argument to be made that this case belongs at the Federal Circuit. And as judges, we cannot expand our own mandate just because we feel sympathetic to a litigant. Congress drew these lines very clearly in Section 1295. If we tried to keep this case, we would be acting ultra vires beyond our legal powers. We would literally be breaking the law in the name of enforcing the law. That's a non-starter.
I agree completely. We are a court of limited jurisdiction. Our first duty is to respect those limits. We are not the court of solving everyone's problems. We are the Court of Appeals for the Federal Circuit. This case involves neither patents, nor the PTO, nor the Little Tucker Act. We have to let it go.
Right. So that brings us to the second point of reasoning, the choice of remedy. Why transfer and not dismiss? And as the 10th chair, my analysis here turns entirely on that interest of justice standard from Section 1631.
Mm-hmm.
Dismissal, in this context, would feel deeply punitive. It's not serving justice. This looks like a good faith mistake made by a self-represented litigant who is, fighting for her home. The system should not be designed to deliver a death blow to her case because she confused the Federal Circuit with the Federal Circuit that covers Texas.
It's an understandable confusion of terms.
Mm-hmm.
To dismiss her appeal would be to deny her day in appellate court based on what is essentially a typo in the address. That is not justice in any meaningful sense of the word.
It isn't. So transferring the case cures the procedural defect without extinguishing the substantive right to be heard. It is the correct and equitable thing to do.
And that leads to our third and final point of reasoning, the restraint shown by the panel. Specifically, their decision in footnote 1 not to rule on the timeliness issue.
This, to me, is where the panel showed true judicial wisdom. As the 10th chair, I would argue very strongly in that conference room against adding any sort of advisory opinion or what we call dicta about whether we think the appeal was timely.
It must be tempting, though. You've already read the file. You see the problem. It's tempting to just say, hey, Fifth Circuit, just so you know, this looks late to us.
It's very tempting. But we must resist that temptation because, to go back to an earlier analogy, we're just the movers. We're the company driving the truck from D.C. to New Orleans.
Yeah.
We are not the home inspectors. Our job is to deliver the box safely. We don't get to open the box and decide if the contents are spoiled.
If we did that, we would be stepping on the toes of the Fifth Circuit. We'd be infringing on their authority.
It's a matter of inter-circuit comity. Of respect. We are coordinate courts in a single federal system. We have to respect their authority to manage their own docket and interpret their own procedural rules. So we hand the file over as is, warts and all, and say, here you go, good luck.
So let's talk projected impact. This order is non-precedential, so it's not binding law. But what does a decision like this signal to the broader legal world?
Well, on one level, it just confirms the status quo. It's a clear reminder to practitioners and litigants. Check your jurisdiction before you file, read the statutes, know where you're going.
But it does more than that, doesn't it?
I think so. More importantly, it reinforces the utility and the grace of Section 1631. It shows that the federal courts are not a series of disconnected islands. It shows they are part of a unified system that can and does talk to itself to solve problems. It projects an image of a judiciary that is cooperative rather than antagonistic.
That's a great way to put it. It makes the whole judiciary feel like a single functional organism rather than a collection of competing fiefdoms. Is one court saying to another, you filed here, but you belong over there, let me hand you over.
It's a functional bureaucracy working exactly as intended, and in government, that's a rare and beautiful thing to see.
It is. I have to say, it's refreshing. We so often look at cases where the system seems to fail a litigant, but this is a small, quiet example of the system actually helping someone out of a hole they dug for themselves.
It is a small mercy, but a very significant one.
All right, let's wrap this deep dive up. Give us the recap for the listeners who might have zoned out during all the statutory citations.
Okay, here's the too long didn't listen version. Carly v. Saalwaechter is a classic wrong court case. A litigant in Texas, Mrs. Carly, appealed her home foreclosure case to the wrong court. She sent it to the Federal Circuit in D.C. instead of the Fifth Circuit in New Orleans.
A huge but understandable mistake.
A huge mistake. The Federal Circuit quickly caught the error and realized it had absolutely no jurisdiction, no power to hear the case because it wasn't about patents or any of the other specific topics on their menu.
And this is the whole point, instead of just killing the case by dismissing it.
Instead of dismissing it, they used their power under the statute 28 USC Section 1631 to transfer the entire case to the correct court, the Fifth Circuit. This transfer preserves her original filing date, which saves her from being automatically thrown out for being late.
But the drama is not over for Miss Saalwaechter.
Not by a long shot. The Fifth Circuit now inherits this case and has to solve a complicated puzzle about whether her appeal was actually filed on time, given a pending motion she had filed in the lower court. But that is a story for another day and maybe another deep dive.
3 pages, 3 judges, 1 clear message. Go to the right court, but if you get lost on the way, the system has a mechanism to guide you there. We just won't be the ones to hear your actual case.
It's efficiency and equity in perfect balance.
And that really is the beauty of the legal system when it works. It isn't flashy, it won't be on the nightly news, but it keeps the wheels of justice turning, even for the people who take a wrong turn.
Couldn't have said it better myself.
Now, before we sign off, we have to do our own bit of legal housekeeping. We are professionals, after all.
Of course. It is very important that you, our listeners, remember that our analysis today, including the judgment we offered in the 10th chair, is commentary for informational and discussion purposes only.
This is not legal advice.
It is absolutely not legal advice, and it does not represent the actual holding or official views of the United States Court of Appeals for the Federal Circuit.
If you are actually involved in litigation and are thinking about filing an appeal, please, for the love of all that is holy, read the rules. Or, better yet, hire a lawyer who knows the difference between a patent and a foreclosure.
That is always the best advice.
And on that note, we would love to hear from you. Have you ever been involved in a case that got filed in the wrong court? Have you ever had a Section 1631 transfer save your case? Or maybe seen one doom it? Send us your jurisdictional puzzles. We really do love to hear about them.
We live for the procedural puzzles.
Until next time, this has been The Deep Dive, Talk Trials. Thanks for listening.
Goodbye, everyone.